1353 is that for all purposes, in any other litigation of any kind, it should be assumed that in fact it wasn't statute barred. Well, why isn't counsel going to be on the hook for a professional negligence claim? Because he will be told, well, for all purposes, if you'd gone and read your book on limitation, it would have said, actually, there wasn't a limitation period.
Yeah, well, my Lord, in relation, that's a good example, and I don't say counsel or solicitors would be negligent in giving the advice they gave at the time, but that's because what you're asking is whether the advice you gave at the time was reasonably given or not. And the advice at the time, based upon knowledge you could have at the time, was it was reasonable to conclude at that time that the limitation period was 6 years.
But that's the same point here. Surely, at the time, the understanding was that there was a limitation defence.
Yes, I agree.
So we're looking at voluntariness in the context at that time. So you can't retrospectively, can you say, at that time, it suddenly changes the voluntariness?
Well, that begs the question as to what we mean by voluntariness.
Well, the assumption, I think, on which this whole argument is being based is that there is or is not a limitation period applicable at the time at which the repairs were carried out. So the example that we're actually dealing with is surely on all fours with the example
it does depend.
I shouldn't be taken as necessarily agreeing with
if I may say so, it seems to me that what you say about the importance of what we mean by voluntariness is very important there, because the examples that have been given are where the legal standard being applied to the individuals does depend to some degree on their subjective appreciation of what was in play at the time.
And what they would have found in the law library if they'd diligently gone and had a search.
Precisely so, but
that's why I was talking about reasonableness.
Yes.
Which is an objective concept.
Yes. But we're dealing with a situation where, certainly as I understood Mr. Rabinowitz's answers to my Lord Briggs, what is meant by voluntariness here, it's simply a purely objective test as to whether there was a legal liability or not at the time. So I think what's being put to you is whether, when you say Section 1353 applies for all purposes, you've actually committed yourself to more than you need to do for your argument.
I don't need to say it's for all purposes. Your Lordship is right. This is for the purposes of if we take here, if you have and take it in stages, we all agree, for the purposes of a claim by the homeowner against the DPA defendant, it's 30 years. That, at least in respect of, a claim which, I think any claim brought by an owner. So the dispute is simply, and I don't have to do anything more than say, for the purposes of a contribution action or an action by a party claiming damages, on the basis that they had a liability, an in-time liability at an earlier stage, that the retrospectivity provision applies. I don't need to go beyond.
You don't, but it destroys the simplicity of your argument that we should read it as meaning for all purposes. Because once we don't read it as meaning that, then the question of which purposes count and which don't becomes much more contested.
And I think actually, but the examples that have been put to me are actually examples that don't prove that what I'm saying, the simple point doesn't arise. So, for instance, as I think Lord Sales pointed out on Lord Briggs' example, when you sue the solicitor for negligence in advising you that it was 6 years, not 30 years, the answer is, if the court says, well, what is the limitation period? It is 30 years, but that has been retrospectively introduced. So when you were advising at the time, it was reasonable for you in that situation to conclude it was 6 years because that was the position as it then stood. Equally, in the examples about the directors, which I believe will all turn on some sort of...
I was postulating that it would, whether they'd behaved reasonably.
Yeah,
so that would be the same.
They have behaved reasonably, but the company accounts, to just follow through your Lordship's point, so the company accounts, even if we look at it today, the company accounts which made no reserve, so in 2021, you make no reserves for these liabilities. But we now know, Parliament has said that the liabilities exist.
Yes.
You may have to reconsider whether or not you have to go back and do something about that, because...
Well, yes, retrospectively, you may say they didn't show a true and fair view, but they did show a true and fair view at the time.
No, you weren't culpable in the sense of you had been delinquent in your duties, but as a matter of fact, they didn't show a true and fair view.
Well, can I give you, if we can just pursue the accounts example a little bit further. So there was a potential liability under the DPA which became time barred.
Yes.
And so the provisions in the accounts were released in respect of that liability after the expiry of the time bar, which would be, I would think, normal course. And then on the strength of that, and slightly as an example Mr. Rabinovitz gave, the company declares and pays a dividend, which it could not otherwise have done if the provision had remained in place. And then we get the new Act in, and the effect, as I understand it, that you put forward, is that at the relevant time of the previous accounts, actually there was a limitation period still running, so that a provision should have been there, and the dividends were paid out of capital, not out of profits. Now, on one view, those dividends are recoverable from the payees because they have received ultra vires payments, illegal payments, not dependent, or arguably not dependent on the directors having acted unreasonably. Would that liability, well, supposing the statute said there was an absolute liability imposed on shareholders who receive unlawfully paid dividends, how would Section 1353 play in those circumstances?
Well, the answer there would be there are two different types of shareholders there. Those who have a defensive change of position and those who don't. But, I mean, the problem with all these examples, you can show ways in which you get odd results. So take the company which declares the dividend on the 27th of June, pays out 100 million, then the statute comes into force on the 28th of June. Nothing surprising about saying, well, actually, we paid it out all under a mistake as to what the position is, and so we're seeking to recover it.
I mean, of course, on the 27th of June, everyone would know the Act was coming into force the next day. But if it was done 2 years earlier, at a time when the Building Safety Act was not in anyone's mind, what you're saying there, that was paid as, I'm not quite sure what your answer is in those circumstances.
Well, my answer is the same.
So there's an absolute liability imposed by statute on shareholders who receive an
It's not the statute, with respect, is not, the BSA is not imposing the liability.
No, I'm assuming the Companies Act imposes an absolute liability on the shareholder to repay an unlawfully paid dividend.
Well, then the question is whether the dividend was unlawfully paid.
Well, that's my question to you.
I'm saying to getting back to what the question actually is.
Exactly.
The question is, was the dividend unlawfully paid?
Yes.
And the question, the problem is I'm not an expert in company.
You don't need to be, I mean, because they just assume those.
No, what I'm saying is I don't know the extent to which the unlawfulness, I'm taking it from your Lordship, is not dependent upon any understanding which may be reasonable. It's just a binary position.
Let's assume.
Well, it makes a big difference to the analysis, but assuming that's so, if that is so, then the consequence of what has happened, it's nothing to do with my argument, I want to stress, in relation to what we're talking about, because this applies...
I know, but I'm just trying to get to what you say the effect...
No, well, I say the effect is that you now have a liability under the DPA, and Parliament says you always did. You didn't ever cease to be under that liability. So insofar as you have made payments out on the premise that you weren't under a liability, then those have been made mistakenly, if one likes, ultra vires. That's the legal consequence of what Parliament has ordered.
Yeah.
I mean, and just to, I don't want to get obviously unduly detained, but if one just follows this through, it's quite difficult to see why that isn't so, if one thinks about it, because the company today, on your Lordship's example, has to make a provision in its account. So why does it make a provision? Because Parliament has changed the law and said now we are liable. You can't, I can't see how you can contort it to say, well, we are liable today, but we weren't liable at any earlier time.
And it all depends on the effect of subsection 3.
Well, but subsection 3 on any view says the 30-year limitation period has always been enforced.
Well, the question there is what, you see, Mr. Rabinowitz has given us a purpose of subsection 3. He said what the purpose is. He says it's to prevent a defendant to DPA proceedings relying on an accrued limitation defence.
Yes.
And he says that's the point of it. That's what Parliament intended to achieve by subsection 3, and that's the meaning we should therefore give it.
Well, can we just look at... Sorry, just 1 minute. Yeah, can we just look at one thing in the explanatory notes on that note, which is, if we could go to 5.2.5.6.
Just before we move away from the example that's been discussed, and I'm not suggesting that what I'm about to say gives the answer to the question of statutory interpretation, but it occurs to me the sort of situation that my Lord Richards is positing with you does have analogies elsewhere in the law. So I'm thinking of the FII case in Kleinwort Benson, where you get cases where European law changes on a declaratory theory what was understood to be the position in relation to lawfulness of tax, and claims are then brought against the government, I think, claiming for recovery of the tax based on mistake of law. And there's a whole debate in the authorities, does the change in European law count as a retrospective mistake of law? And there's a lot of debate about that, but certainly on one view, recovery is granted on that basis. So I'm just drawing attention to the fact that analogies do exist for that sort of situation arising. I emphasise, I'm not suggesting that necessarily gives the answer here.
And I think Mr. Rabinowitz pointed that out right at the start by saying that when you're within the development of the common law, which is necessarily retrospective, you have a clear mistake. When it's a parliamentary change, you have to construe what retrospectivity means. And I think your proposition is, it is so retrospective that it would trigger mistakes of law. And I think the question being put to you is, does it need to go that far? Not least because of the general presumption against retrospectivity. At the moment we've had a fairly clear-cut, I say fairly, a fairly clear-cut purpose which gives retrospective effect, but to a relatively narrow sphere. It seems to me that your submissions want to take it further, and I think the question being put to you is, what is the purpose that would take it further?
The purpose that takes it further, and this is why it's right, we don't have to say it's for all purposes. What we say, it is at least for the purpose of allowing the party who's being held responsible to make onwards claims under the Contribution Act or under any other independent cause of action. I'm sorry, Lord.
It's one way of putting it this. Section 135, though not, I think, subsection 3, does have the effect going forward that repairs done after the commencement date by someone who is in the target of the DPA claim can, as it were, get contribution, whether by contribution proceedings or a totally separate negligence claim, against others to help him foot the bill. This act was passed in the context of the government already having asked developers to go around and look for defects and repair them before the commencement date, sometime before the commencement date. Is it consistent with a purpose that did entitle prospectively people who do repairs after the commencement date to get recovery against other people who might be liable, but not those who actually faced up to their responsibilities at an earlier stage and did the repairs before the commencement date? I mean, was it intended to have that apparently rather draconian effect on people, on enterprises such as developers who actually got on with the job and did the repairs without waiting for the commencement date?
My Lord, you have encapsulated my point exactly, and what I say is you result in a very odd, against that background, apparent policy of Parliament, which is to say to the developers who did what they were asked to do, too bad for you, you are left holding the baby, whereas the developers who dragged their feet and then the Act comes into force get the benefit of that. And in my submission, that I would suggest is an odd policy to say Parliament had. I mean, I think what one would have to say is, well, I mean, Parliament just overlooked this, is if one were going to find against me that Parliament has not sufficiently catered for that situation. But in my submission, one can sensibly construe this Act in the way that I suggest, which does allow it. And the other point I wanted to draw attention to, the objectives of the Act are actually set out at 5256.
And we had this sort of slight point yesterday, didn't we, that these are post-enactment notes, but are they, and we've been supplied with the bill notes. I take it that these notes, I think this was a point you rose to make, actually.
Well, I want the point
that these, are we to take it these notes are the same as the bill notes?
I think that's what you were being told on the letter.
Well, we were supplied, but because we were subsequently, I hope you were too, supplied with the bill notes.
Yeah.
I mean, provided everyone's happy to look at
Well,
this.
I'll be told if I'm wrong, but I think what I'm about to refer to is...
All right, that's fine.
I'm just taking you to 5256, which is the introduction.
Sorry, just on this, I think very strictly what we were given, or the assurance we were given was in relation to particular provisions of the explanatory notes that were referred to yesterday, not necessarily these. So if we could make a plea, can the same exercise be done for what you're referring to as what was done before?
Yeah, we'll check.
But we'll proceed thus far on the basis that these do reflect the bill.
The point I want to make is, I can make it in two ways anyway. One is, this is what the explanatory notes say. The other is, actually, this is obvious that this is what Parliament was intending. The point is this: if you look at paragraph 3, the objectives of the Act are to learn the lessons from the Grenfell fire and to remedy the systemic issues identified by Dame Judith Hackett by strengthening the whole regulatory system for building safety. This will be achieved by ensuring there's greater accountability and responsibility for fire and structural safety issues throughout the life cycle of buildings. Now, and then one sees this involves the third bullet point, increasing access to redress and driving industry culture change and incentivizing compliance. Now the point is, even without this, goes back to the point my lords have been asking me about the policy. The policy following Grenfell, the policy of the government following Grenfell was, this is all disgraceful. The developers who are responsible for these cladding problems and structural defects and things like that should be getting on and repairing them. A problem arose because people weren't, some were, and there was a whole lot of debate where some were doing it, some weren't. And the Act is in part, it's a response to lots of things, but in in dealing with the limitation provision in our submission, it is intended, yes, as my Lord Briggs says, to ensure that you can pass on your claims to those who are responsible, and equally in respect of repairs you've been doing. In our submission, it is entirely consistent with the policy that you should be entitled to do that.
Can you just help us, Dame Judith Hackett's report, do we have that in the bundle?
I don't believe you do, no, and that's, is it in the bundle?
It's in the Secretary of State's.
Oh, it's in the Secretary of State's bundle, thank you.
All right, thank you.
So my Lords, I don't want to echo my learned friends say I've got lots of slides to cover, but I'm only actually on page 3 of my notes. And I wanted to say I enjoy having the dialogue, and indeed it seems to me that the hearing is more useful if we do have the dialogue. But what I want to say is,
you almost got to the position of umpiring a tennis match between various of...
which is what I enjoy. I mean, one could put it in other I have some other points that I just want to make very briefly. You have, I think, my main submissions on 1353. I need to pick up 2 points that my learned friend makes on the other subsections. One is, I think, is 1355, which the point that your Lordships recall was being made by reference to 1355 was that this is the Convention rights protection, and Mr. Rabinovitz said, well, this doesn't apply to, for instance, contribution proceedings. It doesn't allow URS in contribution proceedings to say the fact that you can now bring this claim, passing on this liability to us, which would otherwise have been statute barred, they can't complain about that. So, for instance, they've destroyed all their records, so they're not in a position to respond. They say that this doesn't protect them. Now, the Court of Appeal disagreed with that, and my first point is that's wrong. The Court of Appeal disagreed, and we say that...
Sorry, that's as much as to say, that if you're a defendant in a contribution claim arising out of the opening up of the limitation for the defective building claim, that defendant in the contribution claim can rely on your convention rights.
Yeah, you can rely on this section.
And that provision.
Yeah, that's... Okay. Now, the reason is, I say that comes within the wording, and the way one would construe this would allow you to do that. That's my first point. But my second point is, actually, it doesn't matter in relation to the debate we're having. The reason I say that is once you accept that we can bring a contribution claim today, then if Parliament has said, well, they can't bring, when we sue them in contribution, they can't rely on this provision, well, that's the approach Parliament has taken to third-party claims. And I say that isn't its approach, but it doesn't, I would suggest, inform you about the construction of 1353.
I think that the answer on that particular example would be that URS would be able to say we're not liable under the Defective Premises Act because any action would have to be dismissed because it would contravene our convention rights.
Yeah, but Mr.
That's how subsection 5...
No, I agree.
You agree with that?
Mr. Rabinovitz says no.
Maybe he does, but...
He says this is... then I need to... my point is it's just a...
Yeah, I follow that, but how does that work in relation to the negligence claim?
I say it's exactly the same. In this regard, in the negligence claim, so if what we're putting forward, on ground one we say it doesn't matter that the voluntary out of time, just bear that in mind, but assume we're wrong about that. and it does, so that they would be entitled to say, as they say they are in relation to the negligence claim, it can be struck out on the basis that the liability the damages you're claiming against us are economic loss in respect of a payment you made, which was in respect of an out-of-time liability, and it's only become in time as a result of the DPA. We say that would also fall within this section. If they had something where they said my convention rights have been disturbed,
Yes.
that's much better. I don't want, unless
I mean, I don't want to take this debate too far, but I mean, if there were any doubt about that, then you would get into Section 3 of the Human Rights Act, because if people do have convention rights that could not, would not be respected by allowing claims to be brought against them, then even if this did not in turn say that.
My position is you don't need to get to Section 3 because the court would construe this section as...
I appreciate that. I was just pointing out, even if there were doubt about it.
Right. So that's one point. Then Mr. Rabinowitz raised a new point, which didn't feature in the Court of Appeal because they didn't run the collateral point, didn't feature in his written case. Now, and it was a point which I was surprised to hear because it's obviously wrong, and it's by reference to 1356. I don't know whether you remember this, but what he says is, so you see it says, nothing in this section applies in relation to a claim which before this section came into force was settled by agreement between the parties or finally determined by a court or arbitration, whether on the basis of limitation or otherwise. So as I understand the argument, what my learned friend says is that if you had entered into a settlement agreement, so if BDW had entered into a formal settlement agreement on, say, the 27th of June 2022, then when BDW seeks to come to the court to claim damages or contribution, and the question arises whether when the settlement agreement was made there was a limitation defence, Mr. Rabinowitz says 1356 says that where you've done that, the section doesn't apply and that Parliament has expressly said so. Now, with respect, that is actually not what this is about. The section, subsection 6, is designed to prevent a party reopening a claim as against a claimant which he has pursued to judgment or settled. For instance, if there was a claim by a house owner against a DPA defendant which had been settled or subject to a final determination, it prevents that party using the extended limitation period by vexing the defendant with a second piece of litigation. And that's all that is about. It's got nothing to do with if there had been a formal settlement between BDW and the homeowner, and BDW is seeking to pass things on.
So BDW would then be able to bring contribution proceedings, would they?
Yeah. This is subject to the arguments we've already had about retrospectivity.
Yes, no, but on the basis of your submissions as to retrospectivity, they would be able
Yes,
to.
exactly. Whereas what Mr. Rabinowitz is saying, well, and he's actually saying this section, this subsection, restricts your ability if you'd entered into a settlement agreement. He says it tries to say that's why we don't want to say we entered into a settlement agreement. That's not right. But this is the first we've heard of this argument. But we say that his construction of this is plainly wrong. This is just about saying where the claimant has settled or got a judgment, it can't have another bite of the cherry and say the law has changed and now I want to sue. So the homeowner who did sue and, for instance, lost against the DPA defendant, Parliament is saying doesn't get a chance to sue again.
Nor would you if you settled your claim against the appellant on a perception of a serious risk that you were going to, if you went to trial, fail under the voluntary payments principle.
Exactly.
You couldn't, I mean, this is expressed in very wide terms, it's any claim.
No, I'm telling you, it's any claimant, it's not just the homeowner. No. It would include a claim.
I'm simply looking at your possible implication, what you were saying, they only apply to claims under the DPA by homeowners.
If I said that, it's because I'm
It's really just saying this doesn't reopen settled transactions.
Exactly, that's my point.
Yes.
That's all it's saying, and I was surprised to hear an argument different to that.
Ridiculous.
So, my Lord, I need to just quickly, although you have my submissions, deal...
Can I just check what you said about 1355?
Yeah.
I think you said that looking at where an action is brought, that could include a negligence action which would have been struck out because the payment on which it was based had been voluntary due to a then applicable limitation period. Is that what you're saying? Right, I see. Okay. So
Well, it's a pretty extreme
It's quite a generous
interpretation of the words. I mean, you really have to bring
yes,
convention interpretation into play to get there, don't you?
yes.
Well,
Well, you can.
my Lord, once you accept, I would respectfully disagree. I mean, once you accept, you have to take these things in stages. If you accept that contribution proceedings can be brought, which we all accept, that's not in dispute. Forget the past,
Now.
historic point. Now, so then you're asking, you've got a contribution defendant who says, well, you shouldn't be able to sue me for contribution because my convention rights are upset. In my submission, it's obvious that that is covered, or that it would be very odd to say Parliament, which must have anticipated contribution proceedings, wouldn't anticipate that those would also, the contribution defendant could raise this point, and not just raise...
Wouldn't it raise it in the way I've described? Because the contribution defendant is liable on this basis if it is liable to the homeowner under the DPA. And it would say, look, a claim by the homeowner against me under the DPA would infringe my convention rights. Therefore, they don't have a claim against me under the DPA, and therefore I am not under a liability which is relevant for contribution purposes. But subsection 5 is only dealing with claims brought under section 1 of the DPA.
Well, I don't agree with that.
Okay, well, how do you say it applies more widely?
Well, I say it's a general provision.
It says where an action is brought that but for subsection 3 would have been barred by the Limitation Act, a court hearing the action. That means an action under section 1 of the DPA.
Well, does it? I mean, it says, the question is, so if you have a claim, for instance, if you take the negligence claim, which is predicated upon the limitation period applying retrospectively so that the payments were not voluntary.
No, but that's not an action that but for subsection 3 would have been barred by the Limitation Act.
Well, it is an action that would be the effect of the Limitation Act. It would have
maybe a complete cross purposes. The question raised by 5 is whether this action, whatever the action is, would have been barred by the Limitation Act but for subsection 3.
Yes.
Subsection 3 is concerned only with actions brought under section 1 of the Defective Premises Act.
It is, but the effect of subsection 3 is then also to enliven, for instance, the negligence action.
It may be, but it's not what subsection 5 is all about.
My submission is it does, but I mean...
But I just don't understand how, but anyway, there we go.
If the only way to make subsection 5 convention compliant was to read, I'm not sure whether it's up or down, but to read barred as meaning unmaintainable. Do you then read back that very broad convention compliant meaning of barred for the purpose of understanding its relationship with subsection 3? That's a problem which I'm not sure I know the answer.
I'm not sure I understood your lordship.
If in order to make, if you think that subsection 3 has the effect for which you contend, it would therefore mean that someone, if barred has its traditional meaning as statute barred, it would mean that someone who was bringing a negligence action which was rendered rendered possible rather than impossible, I would have been barred, no longer barred, because of the wide effect of subsection 3 interfered with that person's convention rights. Subsection 5 wouldn't give that negligent claimant, I don't mean negligent defendant, any protection.
Well, that's
Unless you read barred, as I think you do,
I read it,
in a much wider sense.
I read it up.
Yes, read it up. I think reading up is the right word here.
How do you construe the words "would have been barred by the Limitation Act 1980"?
Well, I'm reading that as covering a situation where the effect of the Limitation Act 1980, saying that this claim, the claim you're bringing is in respect of a statute-barred liability, which therefore bars you bringing it, is what's covered. I mean, take the situation of the building built in 2015. The limitation period for negligence, say you've got a latent defect, but the DPA limitation period expired after 6 years, then the negligence claim is brought once the Act has been passed, and we're not talking about anything to do with historic fact, and the defendant says, well, it's jolly unfair that you can bring these DPA claims against me now because I have some convention right.
Yes.
In my submission, but for the change in the law, it would have been barred.
Yes.
In my submission, the section is either on its language or reading it up in order to comply with the convention is broad enough.
Well, I mean, it's very straightforward. I don't think you need to read it up or down, do you? It's simply saying that if you've got a claim under Section 1 of the Defective Premises Act, which but for subsection 3 would have been barred, you can bring it unless the court hearing the action is satisfied that there's a breach of the defendant's convention rights.
Well, my Lord,
are we in agreement that that's the effect of it?
No, my Lord, but I'm in danger.
You give it a much wider meaning.
I do.
I see. So it sort of. I see. So it would apply, you say, to your negligence claim?
Yes, I say two things. I say it does apply. Well, can I just be clear? I say two things. So one, it does apply, but two, it doesn't matter, because this problem that this gives rise to is a problem of, I mean, let's say it is a problem. It's a problem that applies as a result of the retrospective retrospectivity in any event. It's not peculiar to what we're debating in this case. I think that's what's very important. One can put forward these problems and say, what about the negligence case? But you can see there can be negligence cases that can be brought in respect of a DPA liability that had been time barred, but where the developer, say, then becomes liable and is seeking to sue in damages, as we do here in negligence.
Right.
So
yes.
It doesn't.
I think you're saying that the subsection 5 problem would arise, for example, in relation to a new claim brought after the commencement date for negligence.
I do say.
When everybody agrees that not only is there a 30-year period newly created, but also there was no accrued limitation defence, and that point is dealt with by 1353, and that gives rise to a potential convention rights problem in relation to such a claim.
It does, and then you'd have to if it came before the court where a defendant in the negligence case, you would have to decide, does 1355 give that defendant a right to complain, or if it doesn't, my Lord Sales says, that takes you to Section 3 of the Human Rights Act and other avenues to address it.
I mean, very strictly, since Section 1355 is clearly Parliament, one might think, intending that convention rights are to be satisfied by interpretation of this Act, one might say that you get to that answer on interpretation of this Act without needing to resort to Section 3 of the Human Rights Act. And I wonder whether that gives perhaps a part of an answer to the question raised by my Lord Briggs about can one reason back from whatever is said in section 1355 to proper understanding of section 1353, because I can see that if you only get convention compliance under section 1355 by resort to special interpretation under the Human Rights Act, it may be difficult to infer from section 1355, whatever meaning one gives to it, some clue as to the meaning of section 1353. It may be that one can do that if the intermediate position that I was mentioning, that this Act itself is intended to create compliance with Convention rights by itself, on its face, without resort to Section 3 of the Human Rights Act, is the correct interpretation.
Well, basically, Your Lordship I agree with Your Lordship. I think Your Lordship is putting the point that, more elegantly, that I was making.
Mr. Howard, can I just put one more point, or
Yeah.
possibly two? In subsection 5, would you agree that an action, where an action is brought, is referring to an action by virtue of section 1 of the Defective Premises Act?
No, that's, I think, the point
you say that it could include an action for negligence.
Yeah.
But subsection 3 and this section as a whole has nothing to do with limitation periods for negligence action.
No, it's not affecting, but it is affecting the action, or it may affect some other action in which this question arises.
But the action would not be barred or not barred by virtue of this section.
You'll just put that to me, and I've
We don't.
said why I say that.
All right.
I mean, I'm sorry. I can say the same thing again.
All right.
I can't.
No, you can't. Okay.
I'm sorry. It may be Your Lordship doesn't like my answer, but I'm not sure I'm advancing it by just saying the same thing again. I'm happy to, but I'm not.
No, there's no point in that.
Sorry, I hope that didn't sound rude.
Not at all.
So Your Lordship had a second point.
No, they would have followed on from the first.
Well, I'm sorry, I don't want to...
No, it's fine.
Right. So, my Lords, that leaves, the point which I think Your Lordships all understand, my submission on, assume I'm right, that section 1353 is retrospective, and so the question of what was the limitation period when BDW did the works is 30 years. As I understand it, then there is a separate point, a sort of freestanding point, but anyway, you shouldn't treat it as altering historical fact, and so URS say that it gets them out of jail. Now, if I can just give you my simple analysis of what I say the answer to this is, the correct analysis is, forewarned you already. The first is that BDW was liable to the homeowners pursuant to section 1 of the DPA, irrespective of the limitation period. Secondly, prior to section 135, there was a 6-year limitation period. Thirdly, the expiry of the limitation period did not extinguish the liability, but it did mean that it was not enforceable or compellable, or as is often said, limitation bars the remedy, but it does not extinguish the right. See the Court of Appeal, for instance, at paragraph 17, bundle 255. So the fourth point is the payment made by BDW was, even at the date it was made, a payment in respect of liability to the homeowners, save that prior to section 135 and its retrospective provision, it was not compellable due to the expiry of the limitation period. Fifth, at the date of trial, the effect of section 135, or now, is that BDW, as a matter of law, was compellable and never had a limitation defence. So the payment that BDW has made has satisfied its liability, which was in fact compellable, and as it happens, satisfied the liability of URS, which also was compellable. In other words, what BDW thought at the time is neither here nor there. It made a payment in respect of a DPA liability, which has satisfied the liability. And we now know that the limitation period in respect of that liability had not expired. So that insofar as BDW brings a claim for damages against URS in negligence, or pursuant to the DPA, we'll come to that tomorrow, or a claim in contribution, the payments to the homeowners are ones in respect of the liabilities which BDW had, and they were payments as a matter of law in respect of liabilities which were not statute barred, and those payments have satisfied their liabilities. My Lord, I'm sorry if that, of course, this is an important point, and I've given you my headline points, but that, we discussed this on passing, but that's what I want to say about it, subject to any questions you have, and other than that, I'd move on.
Sorry, just one more question,
Yes.
Mr. Hyde. Sorry if it's going back to some extent, but I just want to understand the relationship between your case on this ground and ground one. Suppose on ground one, you're correct that the general test is one of reasonableness and not some principle that you can't recover if the payment wasn't under an obligation. Do you say that in assessing the reasonableness of BDW's action in doing the work, that should be judged by reference to their state of knowledge at the time, or by reference to an assumption that even if they believed at the time that they were under no legal liability, it should be judged the reasonableness on the basis that they were under a legal liability, an enforceable obligation in judging reasonableness?
I'm understanding that the premise of your question is that you don't agree with me on ground two, on this ground.
No, it's not. No, I'm just wanting to understand your interpretation of the purposes for which, how far the purpose, it goes back to Lord Briggs giving the example of the negligent advice and so on, where the limit comes as to how far the purposes go.
If one were judging, in other words, if you're not taking account of the retrospectivity, so that, in other words, it was an in-time liability. Sorry,
I may not have made it clear. On the facts that we have on this very case, on ground one, let's assume in your favour that Mr. Rabinowitz is wrong on his argument that you can't recover, provided it's shown that there was no enforceable legal obligation. And the question is one of reasonableness as to whether, in doing the work that was done, your clients acted reasonably.
Well, the problem is that the reason I'm struggling, there is, Mr. Rabinowitz's argument is dismissed that there's no enforceable obligation. That's the premise. So in other words, there is...
Sorry. If Mr. Rabinowitz is wrong in saying that the test is purely one, that he has a principle that provided that there was no enforceable obligation, leaving aside section 135 for the moment, that he has a knockout answer to your claim in negligence on the basis that there was no enforceable liability. That's his ground one argument. Now, I want you to assume that he's wrong about that.
Yes.
And that actually there's no such general principle, and that it all depends on whether what BDW did was reasonable in all the circumstances.
Yeah, I see. So it's just that the only test one's got, was this reasonable?
Yes, and I want to know whether in relation to that test, what you say about, if that is the test, what you say about section 135, does it alter the position, give you an extra point in your favour, because now in judging reasonableness one assumes that there was actually an enforceable liability, or does one not?
I mean, I'm sorry to say this, I'm still struggling, if I can just explain why, to see how this can ever arise in the way you're putting it, in that, insofar, if I'm right, that, the premise of the Lordship's question, which is Mr. Rabinowitz is wrong,
on ground one,
on his sort of bright line test, And the test is actually, as I say, it should be, it's just whether we behave reasonably.
Yes.
But when we come to consider that,
Yes.
your lordships or the court will already have answered, or you will have answered in these proceedings, ground 2. It won't be considered in the abstract.
That's right, and I want to know whether, well, we've got to answer all the grounds, but I want to see how they relate to each other.
No, but if ground 2 says the BSA it has the retrospective effect for which we argue.
Yes.
Mr. Rabinovic's argument about voluntary payments just falls away.
That's true.
Because it's not a voluntary payment. He accepts that. Take away his historical fact point, then...
Well, perhaps it does, perhaps it falls away, but I still want to know if he's wrong about his voluntary payments point, and we are looking at it in terms of reasonableness, whether you also say that argument, as it were, falls away, that you win on that basis, because one doesn't have to go into an assessment of whether your clients were acting reasonably on what they believed the position to be at the time. One can bring in what we now, are you saying that retrospectivity of the act is relevant to the reasonableness judgment?
Well, in my submission, the answer is that, well, I'm sorry to say the point again, I just don't see what your lordship is putting.
Well, I'm sorry, I haven't explained it, so I have to give up on the point.
Could I have a go? I mean, if the relevant test on ground 1 is reasonableness or natural consequences of the breach, all that sort of thing, so let's take it as reasonableness to stand as a marker for all of that. So the postulate is we don't accept Mr. Rabinovic's bright line voluntary principle. I think that what my lord is asking is, when you come to trial, because it's accepted that issues of reasonableness and so on, I think we will not decide here and now, but we'll go to trial. But when you come to trial, it might be highly relevant for the trial judge to know whether, in assessing reasonableness, the trial judge brings in an assumption derived from section 1353 that in fact you were liable all along, or has to address the question of reasonableness on what was understood to be the position at the time, that you faced time-barred claims. So, as it seems to me, if you were wanting to say section 1353 comes into that reasonableness test, it makes it so much easier for you to succeed on reasonableness, whereas if you can't, it may be quite more difficult for you to succeed on reasonableness.
I would say that all depends upon what your view is of 1353. If your view of 1353 is that it is retrospective, then, in the way that I say, then the question of my having made a voluntary payment doesn't arise.
Well, I think that's what the question is testing, whether that is really right.
Is that your view? That is what you say, is
that
it?
Is what it
that even if the question is not one of voluntary payment but reasonableness, it's retrospective for this purpose?
I'm sorry that I haven't made this clear. The reason I've taken ground 2 first is that we say if the other side are wrong on ground 2 and the payments are, at the time, are not treated as being voluntary because they were, as a matter of law, compellable, then you don't get to a situation where you have to, you may still have to consider whether you've acted reasonably in a mitigation sense, but it will be a given that you did have a legal liability that you were discharging. Now, if on the other hand...
And that would be a given, would it, for the purpose of judging the reasonableness of the action?
Yeah.
It would. Okay, well that's what I wanted to know.
I mean, that's what I'm trying to say. If your lordship is saying, what if we are against you on the way this operates, can you still say that your conduct, that reasonableness has to be judged by reference to section 1353? I think that would be a difficult argument.
No, you've answered my question.
Okay, so I think it is, the logical point is Mr. Rabinovich gets knocked out on his ground 1 completely, just doesn't arise as a question because of the effect of 1353, or Mr. Rabinovich's question arises because you haven't got 1353 and then you are settling an out-of-time liability, and that then raises the question as to whether reasonableness comes in and so on. And our argument is in these circumstances, it's an argument for trial as to whether you behaved reasonably. But I can't, having lost on the retrospectivity, somehow bring it in by side wind, unless the Lordship saying.
No, I wasn't suggesting that. You've answered my question, thank you.
Right. Anyway, those are my submissions. I'm going to move on to ground 4. I don't know whether your Lordships will be in a less or more combative mood about that. Ground 4, as you know, relates to the contribution claim, which is based upon DPA having a liability, BDW having a liability to the homeowners under Section 1, and URS also having liability for the same damage. As it happens, it's a liability under the same statute, but as you know, that isn't actually necessary. You just have to be liable for the same damage. The factual premise is that BDW satisfied the liability by making the repairs. There may be an issue as to whether that's been fully successful, but that would be a matter for trial. For today's purposes, it should be assumed we were. In the Court of Appeal, URS's case was that no cause of action for contribution could accrue without there having been a claim or the intimation of a claim. You see that, I don't need to stand it up, the Court of Appeal's judgment at 194. Now, the argument has now changed, and it's now different. It's that no cause of action for contribution arises until D1's liability to C, that's BDW to the homeowners, is ascertained, and the court is in a position to assess whether or not it paid more than its fair share. That's what they put forward in their written grounds at paragraph 181. Now, by way of introduction, I would suggest there are some very unattractive and odd features of the argument with which you are presented. The first is there is no doubt that for the purposes of ground 4, BDW is liable under the DPA because of defects, indeed dangerous defects, which rendered the homes unfit for habitation. And there's no doubt that URS is also liable. No doubt also that BDW, having discovered the defects, has incurred cost in meeting its liability. Now, the unattractive feature first. URS says that BDW, having discovered these defects, ought to have sat back and waited for a claim to be brought. And indeed, it doesn't shrink from saying that we could only have brought a claim in contribution if only we had waited for the homeowners to actually sue us and then going to a judgment or a formal settlement agreement. Or, and this is a point that has been overlooked in the debate, made an admission. I'll come back to that in a moment. But what they say is, by doing the decent and honourable thing, going in and effecting the repairs in order to protect the health and safety of the homeowners, we jumped the gun. Now, we say that can't be right, just as a matter of policy, and as my Lord Justice Coulson, in relation to the arguments of a similar nature being run below, said this would be a regressive approach. Now, that's the unattractive feature. The oddity is this. URS does not dispute that payments in kind, in other words, the repairs, are to be treated as payments. It appears to accept, when it refers to the 1935 Act cases, that if those payments in kind had been accompanied by an admission of liability, that would be sufficient to trigger entitlement to a contribution. I say that if you go to their written case at page 144, paragraph 190, where they their case of what the law is, which in 189 they are dealing with what liable meant, and they conclude that stopped said it meant responsible in law. But at 190, as regards the second question, which is when does the cause of action accrue, they say it was established the cause of action did not accrue when D1 became responsible in law, rather it accrued once the liability had been ascertained, whether by judgment, admission or settlement. So their case is an admission is sufficient to trigger the cause of action. So if one actually thinks about it in relation to our case, it would appear that if the payments in kind, the repairs have been accompanied by an admission of liability, that would be sufficient to trigger an entitlement. So somehow, to contribution. So somehow it's said it makes all the difference that you have paid or done the repairs without entering into a formal settlement and without admitting liability. But whether BDW made an admission makes no difference to URS, who have actually received the benefit of the repair works in that those works have diminished their liability to the homeowners. What is more, a sort of curiosity about all of this, is that in these proceedings, the predicate of the contribution claim is that BDW avers that it is liable and was liable when it did the repairs as a result of Section 135. So it, for the purposes of these proceedings, is positively averring, let alone admitting, liability, and presumably that will be common ground. Now, there's also an air of unreality to URS's position. It says it can't be liable in the absence of a judgment or settlement agreement between BDW and the homeowners, or an admission by BDW. But as Lord Justice Coulson said in the Court of Appeal, BDW persuaded the homeowners to leave their homes for a considerable period of time, to grant access to the buildings and to live somewhere else. Indeed, I think they footed the bill. The reason the homeowners were obviously willing to do that was that BDW was going to fix the defects. So Lord Justice Coulson remarked that in those circumstances, the absence of a piece of paper is or should be of no account. That's paragraph 204. The real point, as I understand it, is it's that whatever happened, there wasn't a full and final settlement with the homeowners. Now, in our submission, that is neither here nor there in relation to contribution. The payments have been made in respect of the liability and have extinguished or reduced the damage. Lord, a brief word about the 1930...
I'm so sorry, I slightly lost the thread. Are you saying that by effecting the repairs, there's an implicit sort of admission of liability? I didn't follow quite what you were saying.
As my Lord Legate pointed out yesterday, of course, you can enter into a settlement where you don't admit liability.
Yes.
So the mere fact of carrying out the repairs doesn't itself constitute an admission that you were a wrongdoer, but it does, what you're doing is going to, what you're saying is, I'm not formally admitting that I am liable, but I am going to do the repairs for the damage, which I would be responsible for if I were liable.
Yes.
But the point I was making, if the concern is there isn't an agreement with the homeowners, the homeowners obviously agreed to the work being done. All I think you can say in this case, and this is what this case concerns, is there isn't a full and final settlement agreement. So in other words, we haven't engineered a situation where...
Well, sorry, I understood you to be saying there isn't even an admission of liability.
No, there isn't an admission of liability. I can't, other than in fact in the pleadings in this case, we are asserting that we were liable.
Right.
So you could argue whether that actually does now amount to an admission.
I just want to be clear on your case. You're accepting that when the work is done, there is neither an admission of liability nor a full and final settlement.
Okay. That's the premise, that there wasn't a formal admission or any admission, and there wasn't a settlement agreement.
So the homeowners could now bring a claim saying that you need to do more work.
They could,
because it's not barred by any
not
judgment or
barred
admission.
from bringing a claim. They if they brought a claim, let's say you own a flat, and you say, well, they couldn't ignore the repairs that have been done.
No, but they could say that you haven't done enough in the repairs and that there's still a liability to do something else.
Yeah,
And they said that hasn't been, the liability hasn't been discharged by settlement.
It hasn't, what has happened, I mean, if they can find some other damage which hasn't been dealt with by the repairs, then they can sue for that. If they were suing for the matters which were dealt with in the repairs, then they would have to give credit for the repairs, so their claim has been either extinguished or diminished, at least to the extent of the repairs.
Yes.
And that's the question: can you get a contribution where you haven't got a full and final settlement, but you have made payments which have had that effect? Now, what I was saying is there is reliance by my learned friends on the 1935 Act and the cases under that. And we suggest there are two problems with this court relying on the 1935 Act cases. The first is the 35 Act authorities don't actually speak with one voice. Some, you will have seen them and you will read them. But the important thing is that I make is two points. The first is that what was historically, or the first point I want to make is what was historically driving these cases was a limitation conundrum that then existed. There was no special limitation provision for contribution claims. So the courts, when presented with this, faced two unattractive outcomes, potentially. The first was that the contribution right accrued and the time started to run for limitation purposes at the time of the primary liability. So if you had a car accident, that would mean that the contribution claim time started to run. And the difficulty for that is the obvious one, that you could become time barred for your contribution claim before the main claim had even been brought, let alone concluded. In other words, where you have a 6-year limitation for tort, the victim of the car accident waits until the last day of the 6 years to bring his primary claim, then you're out of time for the contribution claim. So that obviously is unjust. The other difficulty, though, is that, or you could avoid this by treating the contribution right as accruing at the time of judgment. But that gave rise to the opposite difficulty, that the contribution claim could run for another 6 years after the judgment in the main claim. So if somebody waits, if the victim of the tort waits 6 years to sue, and then that trundles through the courts, perhaps in a rather lackadaisical way, we're all familiar with that, and it takes 10 years, then you'd have another 6 years to bring your contribution claim. Obviously, we don't like stale claims like that. So that was the tension which motivated the 1935 Acts. And the law, we suggest, was being contorted to avoid unjust outcomes. Now, Parliament stepped in between the 1935 Act and the 1970 Act when it passed the 1963 Act, which you've seen, which provided a 2-year limitation period for contribution claims. And such a contribution claim, it's not in identical terms, and that's a point we'll have to come to, is contained in the 1980 Act. Now, having provided this 2-year limitation period, there was no longer any need, and there no longer is any need, for the courts to manipulate the time of accrual to avoid an unjust limitation position. And the result, as I will suggest to your lordships, is a relatively simple landscape, where contribution claims become available as soon as two parties are liable for the same damage, and a separate limitation regime applies, whereby time starts to run separately from the date of a judgment, settlement, or payment, and that's very important. Now, can I mention at this stage, I mean, we're going to look at several authorities, but we don't need to turn it up, but refer you to what Mr. Justice Hobhouse said in a case called Lister.
Just before you go there, could you just repeat that proposition that you put forward? You said, as I understand it, 2 possible accruals? Am I wrong about that?
Yes.
Could you just repeat that?
Sorry, of course not. We say the way the Contribution Act works is the cause of action accrues as soon as, at the moment in time, when the two parties are liable for the same damage. That's when the cause of action accrues. At any time after that, you can bring a contribution claim, but separate to that, there is a accrual for the purposes of limitation, and for the purposes of limitation, it is from the moment of judgment, settlement or payment. And that's to bring finality and to strike this, as Lord Justice Ricks, I think, put it, it's to strike a balance between these two extremes that I was explaining to you earlier.
So you have two different accrual periods?
Yes, exactly. And I'll show you, we need to look at the analysis that is taking place in the authorities on
it. It sort of brings to mind the concept of a limitation constantly, accrual constantly refreshing itself, where there's a continuing breach of covenant, for example. You can start when the breach starts, but time doesn't stop running 6 years after that if it's a continuing breach. You can go on relying on any later date upon which there's still a breach.
Yes.
But that's quite different theoretical justification for the
What are you contributing to, though, at the initial stage? Until you've made a payment or incurred a liability to make a payment, there's nothing for the other party to contribute to recover contribution in respect of, using the words of the Act.
Well, my Lord, jumping into a point obviously I was going to address, but let me answer it straight away. In our submission, the way the Contribution Act works is that you can start, what you're seeking is a contribution in respect of the liability for the damage, and you may not be able, you wouldn't get a monetary.
But that's what a contribution is. It's a money sum that gets assessed under Section 2.
It can be a declaration that you're entitled to a 50% share of the damages which in due course may be awarded against either party.
You say that's a contribution, do you?
I do.
Okay.
And that would be an order for contribution, which you would make because there was a cause of action that had accrued.
So a declaration is an order of contribution?
Well, I'm sorry, I didn't catch that.
Sorry, I may have misunderstood. I thought you were saying a declaration at that point constitutes an order of contribution.
No, a declaration, you have a cause of action which you're entitled to contribution. You haven't actually paid anything at that stage, so the court would be very unlikely to award you a monetary sum, because the court would be unlikely to assess what the damages suffered by the original claimant would be. The court, in the light of your cause of action, if it says you are 50% responsible, could award you a declaration that the other party is either liable to indemnify you or to contribute in whatever percentage the court determines.
I mean, isn't it going to be very difficult for a court to work out in advance what the proper contribution is according to the Contribution Act, because it's whatever sum is just, I can't remember the phrase, but just and equitable in relation to the liability. So there are two unknowns. One is what is the final extent of the liability, and secondly, in the light of the particular nature of the damage, what's the just and equitable division?
What the court is going to be, well, there might be a situation where the court says, on your particular facts, I can't do it. You take a road traffic accident as an example. You have two drivers driving different cars who've knocked somebody down. The court would be able to assess the extent of the liability for the accident. So, I mean, on the facts, it might be saying, well, actually, you were both driving badly, but one was more culpable than the other, and so you're liable in the proportions 75-25 or something like that.
But do you say that's a contribution, do you?
I do.
Because, I mean, from a more natural reading of the Act, a contribution is a sum of money.
Well,
That's what you're seeking to recover. You may get a declaration about what sum you're entitled to, but to be entitled to recover a contribution, then you must be capable of recovering a sum of
Can I
money.
just get this all in context in this case? I don't want us to lose sight of what this case is about. In this case, we have made payments in kind. So we are seeking contributions in respect of those payments.
Absolutely.
So
That's your second proposition, though, as it were, your second time.
To some extent, the debate, we say, doesn't really matter, in that if a payment is sufficient, then we say the right of action has accrued in respect of that payment.
I understand that.
So,
But you've got two limbs to your case, and I'm addressing your
No,
first
I
one.
appreciate
You've got your second argument, which starts from when a payment is made.
exactly.
But just looking at subsection 2.2 on page 7439, subsection 2.1 looks as if you're just talking about payment, identifying a payment. But subsection 2.2 appears to give the court a statutory power under the Act to direct that the contribution to be recovered from any person shall amount to a complete indemnity. Does that mean a particular payment ordered shall amount to an indemnity, or does it mean that you should be liable to indemnify for whatever the your ultimate liability, D1's, happens to be? I'm just trying to understand whether there is a statutory power that goes beyond ordering a specific sum to be paid, or whether you're in the realms of equity of doing it by way of a declaration.
Well, in our submission, section 2.2 is illustrative of the fact that the court has an extensive power, and it's including a power to exempt somebody from liability. Direct contribution to be recovered shall amount to a complete indemnity. In our submission, it would be it is quite a strange position. Say the situation. Let's take the situation of the simple situation of the accident, the car accident, and the victim is writing to both car drivers, saying you're both responsible, and let's say they've got some enormous damages claim. One of them says, well, it's really not my fault. It's really entirely the fault of the other one. I appreciate this. The litigation with the claimant may take some time, and they're not getting on with it because they've got to get all their medical reports and so on. But I want to not jump the gun, but I want to deal with this to ensure that get an order that I'm entitled to an indemnity that is of value to me, and the court can declare that or order that the other driver is required to provide me with a complete indemnity against any claims from the victim. In our submission, there's nothing at all surprising, I mean, as to that, as to how the Act should work.
Yes, I mean,
But it's
this comes in
2.1, so it talks about proceedings for contribution.
Yeah,
And subsection 2 shall have the power in any such proceedings.
yeah, but
I wondered, Mr. Howard,
Yeah.
just possible reading, that subsection 2's got a limited purpose, which is simply in proceedings for contribution.
Yeah.
It might otherwise be thought there had to be some sum, but couldn't be a full amount.
Well-
What subsection 2 is saying, it can be either nothing or everything.
It's saying you can get 100%.
Yes, and it isn't actually going any further than that. And it's under, I mean, the heading of the section, I don't know if that's admissible, simply says assessment of contribution.
Can I, because we sort of jumped in the middle, I'd like to sort of go back a stage. What I was, just so we can sort of get the structure of it, the point I was referring you to in the Lister case, a judgment of Mr. Justice Hobhouse, as he then was, it's at 8013, where what he said was the Act, as stated in its preamble, actually, if you've got the Act open, you can see the preamble says it's an act to make new provision for contribution between persons who are jointly or severally, or both jointly and severally liable. And he said there was no presumption of continuity with the previous case law. And we say that's right. Now,
Sorry, where does he say that? Can we
he
just
says
have the
that
reference?
it's at
8013. is that?
8013, and it's at
F.
Yeah.
it's at,
F, I think it is.
sorry, I'm just finding the reference. It is on at 8013 at F, yeah. The Act was a new provision, and therefore no presumption of continuity with the previous case law can be made. And that, if we then go to the Act and we see how this has been analysed in the recent cases. So the starting point, and that's what in our respectful submission is actually straightforward. So section 1.1, if you approach this, as it were, with your mind uncluttered by the analysis under the 35 Act, what you see in section 1.1 is any person liable in respect of any damage suffered by another person may recover contribution from any other person liable in respect of the same damage, whether jointly or otherwise. Now, if one would have thought, if you just look at section 1.1, and you were asking yourself, what are the elements that need to be satisfied to have an entitlement to claim contribution, you would see there are only three ingredients in section 1.1. D1 has to be liable to C, D2 has to be liable to C, and they have to both be liable in respect of the same damage. It says nothing whatsoever about a judgment, settlement, agreement or payment, or that the quantum of liability has been ascertained. Now, can we then go to the Aer Lingus case?
So is this right? You're saying the cause of action now is that established by section 1.1?
It is.
And those elements, that's your cause of action?
That's right. That is what I say.
And that's what Lord Justice Coulson said with his three checks. I think,
Exactly.
wasn't it?
That's exactly what Lord
But
Justice...
our question is whether that's insufficient.
Well, that's
There's an added element which your opponent has said is ascertainment.
Exactly.
I mean, you're coming to that.
My Lord, that's the debate. And Aer Lingus is at page 7644. You've already been referred to, but I would like to draw your attention to first to 7646, paragraph 6, where I mean, it's not just Lord Justice Coulson who said this. So you see at paragraph 6, this is here Lord Justice Riggs, as the liability to contribute proceeds by reference to the fact that two persons are liable in respect of the same damage, doesn't mean the same damages. And then he refers to Lord Bingham in the Royal Brompton Hospital case, where who says, where any claim for contribution falls to be decided, the following questions, in my opinion, arise. What damage has A suffered? Is B liable to A in respect of that damage? Is C also liable to A in respect of that damage? I don't think it matters greatly whether, in phrasing these questions, one speaks of damage or loss or harm, provided it's borne in mind damage doesn't mean damages. It's a very important point. It may be observed, Lord Justice Ricks goes on, provided the liability is in respect of the same damage, the liability to contribute appears to arise at the same time as the primary liability to the person who has suffered the damage. As often happens, the same action incorporates both a primary claim by A against defendants B and C and a contribution claim between B and C. For these purposes, it is not necessary for the quantum of A's claim to be established before the court can assess the quantum of contribution between B and C, for that quantum can be assessed as a matter of the respective percentages of their liabilities. And
So that is, that in a sense is directly addressing the point about the possible meaning of section 2.2.
Yes, it's
And it's assessed by way of a percentage, not just by way of a sum of money.
Yeah, it's addressing both section 1.1 and saying the court has that power. And he goes on at paragraph 10, and at paragraph 10 he's dealing with this question of having a cause of action accruing for the purposes of being entitled to bring a contribution claim and a cause of action for limitation purposes. And at paragraph 10, he's quoted, as you see, the section 10 of the Limitation Act, with which you're familiar. And then he says, the following matters may be noted about it. First, the references to any damage, and to that damage must be a reference to the same concept of damage as in the 78 Act. Secondly, although the 2-year period is said to run from the date on which a right to recover contribution accrues, it's difficult to think in the absence of contrary authority that that expression is intended to convey that the cause of action for contribution under the 78 Act only arises at the time of any judgment, whatever that means, award or payment or agreement to pay. For otherwise, a defendant could not claim contribution from another defendant, or at best could only do so contingently until his own liability, and perhaps the quantum of it too, had been established, or the payment or agreement had been made. Moreover, the 78 Act, which creates the right to contribution, is written in terms of the mere occurrence or concurrence of liability in respect of the same damage. There's no apparent need for that liability to have been established. On the contrary, Section 1 makes clear a person may be entitled to contribution even when he ceased to be liable or following a bona fide settlement whether or not he is or ever was liable. The difference between 78 Act's person liable and the 80 Act's held liable or makes or agrees to make any payment would seem to be clear and deliberate. The cause of action for a contribution only arose after judgment, award or payment made or agreed. Then a defendant could never claim contribution from a co-defendant or another party joined in him to the claimant's action for the purposes of a claiming contribution at any earlier stage. But that is something which happens all the time. Rather, Section 10 is stating that a special time limit for claiming contribution, as the heading to the section indicates. And the concept of the right accruing is fashioned merely for the purposes of dating the beginning of the 2-year limitation period. So what is clearly being said there is a distinction between the time at which a claiming contribution becomes available, which is when the 3 ingredients of liability mentioned in Section 1 are satisfied, and the moment when time starts to run from a limitation perspective, which is governed by the wording of Section 10. At paragraph 11, I won't read it out, Lord Justice Ricks explains what he sees as the policy of this. So, in our submission, that is a sensible and clear analysis by Lord Justice Ricks. Now, you also...
Can I just, are you going to take us to section 10?
Oh, yes.
Yeah, okay.
Yeah.
I was just going, when you get there, I was just going to point out that, in fact, section 10 creates its own definition of what counts as accrued and the relevant and the relevant date. So it's not necessarily the case that it's relying on the common law idea of accrual or anything like that.
It's a freestanding...
You're going to come to that anyway.
Yeah, but I mean, I can just answer your little point. Section 10 is its own code.
Yes. Yeah, that's what I was... Yeah. I suppose that... I'm being slow here, but I think that's the thrust of your argument, where you say, well, you have the accrual in law, and then you have the accrual for the purposes of the Limitation Act. Which you started with, and I didn't fully understand. But
right. That's right. And if you look at 7648 still, Lord Justice Ricks, and you drop down to paragraph 11. If we look at it 8, it's considered the 2 different situations as to limitation, and he said In the former case, there would be a danger that the claimant in contribution would be time.
Sorry, you're reading from paragraph 11.
Sorry, paragraph 11, I was just below.
I'm sorry, I didn't hear that.
Sorry, my lord, at just below G, 7648 in Ricks.
Yeah, letter G.
Sorry, Lord
Thank you.
Justice Ricks.
Thank you.
And the sentence in the former case,
Yes,
there would
got
be
it.
a danger that the claimant in contribution would be time barred even before he knew he was being sued by the person who suffered damage. Whereas in the latter case, there would be a danger that the right of contribution, being a creature of statute, would have no limitation at all, or if any, by analogy, too extended a period. Section 10 may therefore be said to provide a form of compromise. That's what it was. Now, can we just look at one other authority?
Can I just, I think Mr. Rabinovitz told us yesterday that Lord Justice Ricks went on to express all this rather differently, or that it was a marching up the hill and down the hill again. Since you're taking us to the authority, are there further passages we should have in mind?
I think what one needs to be careful about what was being said. The analysis that I've shown you about when the cause of action accrues and how and that part of the Limitation Act, that's what Lord Justice Ricks had to say about that. Right. As I understand my learned friend, he says if you turn on to 7655, this is where he's discussing
7649. Wimpy and so on.
Sorry, which page do you want?
My lords, it starts at 7649.
He has a discussion about the authorities at 7649. And if you go to paragraph 26 on 7651, which is where he is commenting on the Wimpy case and the House of Lords. He says, the remarks in the Lords are clearly obiter, concerned with an issue which was not before the House and proceed on the basis of assumption only. Moreover, on the facts, the judgment in question was a judgment for damages and not on liability only. However, on balance, I would regard these dicta as all being consistent in understanding the reasoning of the Court of Appeal as proceeding on the basis that the ascertainment by judgment of the quantum of liability in question was relevant to the accrual of a cause of action for a contribution, and thus to the running of time for purposes of limitation. So I don't think it's right to regard Viscount Simons as speaking purely for himself in his reference to the existence and amount of Wimpies, and he says, then refers to romance. But you've got to remember the debate here was as I would suggest that he's having at this stage, is a different debate.
He ultimately had to decide whether the claim was time barred, and therefore he had to apply Section 10.
Exactly.
And I think when he does say, when you get to that, well, he's talking about time running from when the liability was ascertained by agreement or judgment.
But that's the limitation issue. Yes. In relation to the issue that I'm interested in, he says what he says. I mean, you may agree or disagree.
No, I follow that.
He's not, it's wrong to say Lord Justice Ricks was equivocal about that.
Right.
He was actually entirely clear. Now, the other authority that I wanted to briefly look at is the Santa Fe case, which is at 8060. And if we go to 8063, this is Court of Appeal Authority telling you the approach to the 35 cases. So if you go down to the paragraph, it's two up from the bottom, in support of the argument, Mr. Hooper referred to Wimpy. in the Court of Appeal and Ronex, all of them decisions upon Section 6 of the 35 Act, which contained earlier provisions for contribution. These cases show the courts were prepared to hold that upon the provisions in the 35 Act, the cause of action didn't arise until the party claiming contribution had been held liable. In my judgment, these cases can provide no assistance in deciding the issues in this case. The 78 Act, as the title makes plain, and he sets that out, and then...
I misheard your page number. Which one are you on? 8063?
Sorry, 8063.
Yes, I'm sorry, I'm just not finding it.
Nearly at the foot of the page.
The last full pen.
8063 should be...
Wimpy's in blue
Yes,
on
got
my
it.
picture,
Yes, thank
on
you.
my
Right.
screen.
Yeah,
Coloured it already.
No, you have.
yeah.
And at the top of 8064...
So the new provision point is the same that Justice Hobhouse had made before.
This is the Court of Appeal saying it. At the time, Mr. Justice Hobhouse was a puny judge, and
I think these are dicta though on any view.
yes. But what the Court of it's dicta, I agree. But what they said in the first complete paragraph is it's relevant to decide the purposes of applying the words in Article 5.3 to the facts of this case. When a cause of action per Santa Fe to claim contribution arose, it seems clear to me it arose, as the learned judge held, when the accident happened in consequence of tortious acts on the part of both of them. That is, while it's a claim about, a case about jurisdiction, as my Lord Legate says, it speaks with the same voice as the Court of Appeal in the Aer Lingus case.
It does.
So our submission is that those dicta are correct, and if one goes back to section 1.1, that is governing. Now, if we then look at the other subsections of section 1, section 1, 2 and 3 deal with the situation where liability has become time barred. We'll address that in the context of the limitation debate that we have done. Section 1.4 is important in that it extends the right to claim, or what it does is, your right to contribution is in 1.1. What 1.4 is then saying is a person who has made or agreed to make any payment in bona fide settlement or compromise should be entitled to recover contribution, provided, without regard to whether he was ever liable, but provided he would have been liable assuming the factual basis of the claim against him could be established. In other words, what that means is you don't go into the underlying facts, you just look at the facts asserted. If those facts asserted would give rise to liability, then that would be sufficient.
If I could just take you back to subsection 2.
Yes.
Does that not indicate that an assumption that contribution is something that is sought in respect of a payment that someone has made or was ordered or agreed to make?
The answer is yes, but it's not saying that's the only circumstance. That's really the point. Of course, if you have made a payment or settled or had a judgment, a fortiori, you are entitled to seek contribution. The question is whether that is a necessary prerequisite.
I know, yeah.
So, yeah, I mean, the heading of section 1 is entitlement contribution, whereas 1.1 is what is actually saying when you're entitled, we would say. 1.2 is simply saying that entitlement isn't taken away because you have now ceased to be liable as a result of making a payment. And 1.3 is saying that the third party, the party against whom you're seeking contribution, shall be liable unless, he's liable unless the claimant's right against him has been extinguished. And so as a...
Yeah, no, that, I don't think that bears on it, but...
No. But what we do lay stress on is 1.4 for this purpose, is that the reference is to making a payment or agreeing to make a payment. So the draftsman of the statute who says a person who has made payment, the draftsman of the statute clearly considers the making of the payment is sufficient to trigger a right to contribution. And in the Aer Lingus case, we don't need to turn it back up again, but if you look at paragraph 10, Lord Justice Ricks plainly recognises this and refers to payment in the alternative to judgments, awards or agreement to pay on, I think, something like 10 times.
Sorry, you were using 1.4, did you say? Or did I miss
1.4 refers to a person who has made or agreed to make any payment.
Yes, but in the context of a settlement or compromise.
Well, yes, but the payments that have been made in this case are payments that are in settlement. They're just not the subject of a full and final settlement. If you go in and do the repairs, the extent to which you have reduced the damage has settled, is a settlement. It's just you haven't got a release as a result of doing that. But it's still a settlement of your liability.
Well, you could read the more natural reading. I would thought a settlement means something that discharges your liability.
Well, the question is though, why, I mean, assume you have a situation where you can't, take our situation where the homeowners say, are not prepared to enter into a settlement agreement with you. Say, well, you're responsible, get on and do the work. BDW say, please sign this agreement, agreeing that this is in full and final settlement. They say, no, I'm not prepared.
No, well then you couldn't, what's wrong with saying that in that situation you can't rely on the advantage that Section 1.4 gives you of being able to dispense with having to prove the factual basis of your claim?
My Lord, I accept you've got to prove the factual basis of your claim.
Sorry, I thought you were saying that this was a case, our case was one where Section 1.4 applied.
No, what I'm saying is, what one can see is that the Act actually contemplates that if you've made a payment, that will trigger or give rise to a right to contribution.
If it's in bona fide, I mean this is only dealing with the payment in bona fide settlement or compromise of a claim.
Well, what it's
It
doing
doesn't
is,
tell you, it's neutral as to whether you can claim in the absence of a
your
settlement.
Lordship is right. What this is giving you is an additional right. It's saying where you've got a settlement,
Yes.
a proper settlement, then
You don't have to prove the factual basis of your claim.
the contribution defendant can't go behind that if it's bona fide, providing the facts that were asserted against you were sufficient to amount to a claim, a liability, if proved.
Yeah. I mean, surely I'm reading Section 1.4 as, if you like, an extension of the basic model which you get from Section 1.1.
It is.
It's saying, in certain circumstances, although under Section 1.1 ordinarily you have to prove that you are liable, you're dispensed from having to prove that in this particular situation.
Exactly.
But you will be treated in the same way as if you were liable.
In our submission, it supports us that it's sufficient if you've made a payment that it may not be that you get the benefit of 1.4, but if you've made a payment, that still gives, you're still entitled to a contribution. The point is that there's nothing in this Act which says it's got to be ascertained.
I mean, 1.4, I'm just struggling to see. I think you're not saying it applies in this case, is that right? Or I'm unclear.
Yeah, that's what I was unclear about.
Yeah, sorry, I may have
You were saying that
misled
there
you.
was a settlement here, albeit...
We're not saying there was a settlement.
No, because there hasn't, I mean, also it does require a claim to be made against the person claiming.
It does.
That's difficult to fit on the facts.
Yeah.
So just so I can get it clear in my mind, you're relying simply on Section 1.1.
We rely on Section 1.1,
And this argument about Section 1.4 is just to assist with interpretation of Section 1.1. Is that right?
Exactly, that's right.
But it doesn't give any indication you could claim before you've made a payment or agreed to make one.
Well, except for the words of section 1.1.
Oh, I know, but I thought that section 1.4 doesn't bear on that question.
Yeah. Yeah, I mean, section 1.2 uses the same terminology. So if one looks at the scheme, as your lordship say, 1.4 is giving you an additional right. 1.2 says in the proviso, you're entitled to recover contribution provided you were so liable immediately before you made or were ordered or agreed to make the payment.
Yeah.
So 1.2 uses making a payment separately from being ordered or agreeing to make the payment.
It does. So that may fit well with your second argument, your second way of putting the case.
Yes.
I'm suggesting that it doesn't fit well with your first way of putting the case because it suggests that the entitlement is something that arises in respect of a payment that you've made or been ordered or agreed to make. And,
of course,
and not when you haven't made or been ordered or agreed to make a payment.
But if you won't need 1.2, 1.2 is providing a protection for you. So if you made a payment, what it is saying is providing immediately before making that payment, you were liable, you have a right to contribution. If you haven't made a payment, you don't need that protection.
Well, you might. It's not only saying that you've ceased to be liable because of making the payment, is it?
No.
You could have been ceased to be liable for some other reason.
No, but that's right. But if you've ceased to be liable, then you won't need to seek a contribution because you're no longer liable.
Sure. I see.
What 1.2 is
unless you've
saying,
committed yourself to making a payment.
1.2 is saying, even though when you come before the court, you are not liable,
Yeah.
but you were liable immediately before you made the payment. That's what's it.
Okay.
So that's what that's protecting, that I did the repairs,
Yeah.
say, and providing when I did the repairs, immediately before it I was liable, the fact that for some reason now I'm not liable doesn't matter.
Well, because, yes.
I mean, it could be for all sorts of reasons, as your lordship
Well,
says.
because you made a full payment.
It could be.
You extinguish the liability by your own act.
Of course, it could be that, but it could be there are other things.
Could be others, could be time bar or...
Yeah.
Just again, so I keep it clear in my mind. I think you're saying basic cause of action in section 1.1, and then you get explanations about how that operates in slightly unusual circumstances, section 1.2, section 1.3, section 1.4.
Exactly. And they're
all working on the same model that section 1.1 is the model of liability.
They don't detract from the words of section 1.1 and the overarching provision that you get a right to contribution simply by being liable in respect of the same damage.
I suppose you could say that the word notwithstanding, read in context, rather presupposes that your entitlement isn't based upon having made the payment or there being a judgment or an agreement. You have the entitlement, and that doesn't go away just because your continuing entitlement, your continuing liability to D1 to C doesn't carry on all the way through to the hearing of D1's contribution claim.
Yeah, I mean, that's
I understood 2, the point of 2, to be to qualify, if you like, or extend 1, because 1 requires the person seeking contribution to be liable.
Yes.
And 2 is dealing with a situation where they've ceased to be liable, and that's the point of the word notwithstanding. And then the proviso sets out the condition, and that's all. That's what it does.
It all reinforces the notion it's the liability that creates the right to contribution rather than its ascertainment.
Exactly.
Then the question is liability when? And I think you say liability when the damage occurred.
Yeah, exactly. That's
your construction.
That's our construction, that's right. My Lord, so if I can turn to the argument that damages must be ascertained. Now,
just before we go away from the Act, do the books on procedure help on whether Section 2.2 is in fact frequently used to get a percentage rather than a fixed sum of money? I'm thinking, for example, of Atkins court forms.
Yeah.
Does a contributions claim say X or a percentage, for example? I just don't know. I don't know enough about these things.
2.2 doesn't bear on that. It's quite common for a judge to do percentages without calculating the sum of money,
Yeah.
and then leave it to the parties to work it out.
well, I mean, that depends. I mean, it's quite common, but I think that we may be talking at cross purposes. Quite common, I would suggest, which is what Lord Justice Ricks was saying, for courts to be determining percentages of liability when there is no quantum that has been determined.
That's between the claimant and the first.
It hasn't yet been assessed.
Yeah. That's, or you I mean, you may have a situation where there's a judgment on liability, and you decided, or there may be a situation where actually there hasn't been a judgment on liability at all. It's, I would suggest is something that happens day in, day out.
Sorry, forgive me, Mr. Howard, what happens day in, day out?
The determining proportion of responsibility, and therefore liability intersay to contribute.
Yes. When?
I'm sorry.
At what point would it...
Before there's any determination of the quantum.
Of the quantum. So you've got liability established. So it can happen at the end of liability.
You can have, I'm saying both. You can have a situation where it's been held that the parties are, the two, D1 and D2 are liable to claimant. But you can also have a situation where the claimant's not there at all. But what we're saying is you can have a situation where D1 is suing D2.
Yes, or claimant against D1, and then D1 third parties D2.
Yes.
Claimant not bothering to sue D2. If you're sort of in your, well, the claimant may say, I'm just going to go against this defendant. I'm not bothering with any others because I think he's 100% liable and he's good for the money.
Solvent,
So the defendant, then third parties, someone against whom he seeks contribution. So what I'm understanding you to say is that it's common practice at the end of the liability trial for the judge to say, well, defendant is liable to claimant, third party is liable to contribute, and third party is liable to contrip-ute 40%.
Yeah, that's absolutely, that is, I'm sure all of you stand at first.
And all of that clearly before any damage, before the damages have been ascertained.
And that is, I mean,
that's a commonplace.
yeah, I mean,
Just nice to see it in a book somewhere.
yeah, no.
Well, Lord Justice Ricks, didn't he say it was common fixed percentages or something?
Well, he did it in the case called Dubai Aluminium and Ceylon.
Yes,
In
a notorious case.
he assessed it in percentages being Lord Justice Ricks like 37.5% and 17.75%.
Well, none the worse for that.
Well, if that's a convenient point to stand.
Yeah.
We'll rise now and we'll sit again at 2 o'clock.
Yeah.
Thank you very much.